number 81 of At Your Service with Haber and Martinez. As you can see, I'm Haber, and as you can see, Martinez is not here, but we are joined by Mark Morris, my partner and trial counsel. We've been working together for many years. Mark has appeared on the show in previous episodes. Ed is unavailable today, and Mark kindly agreed to fill in. And coincidentally, as you know, over the last couple of weeks, Ed and I have basically been dissecting various cases that we've pulled out of the news media, most of which we've been able to receive the probable cause affidavits for, so we can talk a little bit more intelligently about. But still, there's only so much you can say when you don't know other things about the case that any competent, ethical, and professional and responsible criminal defense attorney would need to know. For instance, speaking with the client, knowing something about their criminal history, their unique individual circumstances. Do they have any special needs? Are there any things that stand out? Who's the judge? What are the tendencies of the prosecutor? Without knowing these things that we call free radicals or variables that apply in any case, there's only so much that we can say. And so we tailor and limit our show to that which we know. In this case, it's a little bit different because Mark and I are going to talk to you about a case that we actually worked on and just resolved last week. We were hired in mid-2021 during the height of COVID for a 2-kilo cocaine trafficking case with very interesting facts and an interesting client. And it took about close to 2.5 years to resolve, but it did get resolved, and it got resolved quite favorably for the defendant. Before we get to that, I want to just recap that's the caption of today's show, which is Anatomy of a Win, how a 2-kilo cocaine trafficking case wound up dismissed. So with that, Mark, thank you for coming on today. Appreciate having you.
My pleasure. Thank you for having me.
It's great.
Good to see you.
Yeah, outside of a courtroom, right?
It's been about, 48 hours or something?
Right?
Yeah.
Listen, we worked on this case for an awful long time. A lot went into it. There were a lot of curveballs. And I hope that we'll leave the audience today, not only with some interesting anecdotes and pro tips, but I want them to understand, like the number one, like the first rule of Fight Club. The first rule of litigation, criminal defense litigation, certainly is expect the unexpected, because anything can happen. And because of that, this is why if you do get arrested and charged, or if you're being investigated by the authorities, you need a lawyer. You have to hire a lawyer who's got skill and experience, who understands the system and who knows how to game it, who knows how to play with the rules of evidence, with the rules of criminal procedure, who understands how to, in short, manipulate everything to your advantage to the best of their ability. And so that's exactly what happened in this case. At least ultimately, that's how it worked out. You want to tell the folks a little bit about the facts and circumstances?
Well, yeah, Mike, since we're talking about our case, let's start from the very beginning, the phone call. Maybe a lot of people out there don't know how something like this starts, but we get, it usually starts with what? A phone call from an individual saying, hey, I need help, or I'm calling you on behalf of somebody that needs help who's in custody. And that's exactly what happened in this case. Now, I don't know how we don't want to get too much into the background here, but this was a referral case. And if you want to explain to your viewers what referral means in our business, how did the phone ring here? And what is the first thing that we did when the phone did ring here? And what is the first thing that we usually always do for people when they call up, when somebody is in custody, when they call? When I say in custody, they're in jail. They've been arrested, they're in jail. There's a bond that's set. Maybe they can't make the bond. Maybe there are conditions to the bond that need to be addressed. In this particular case, the bond and getting the client out of jail was item number one. That was first item of business. Remember that?
Oh, yeah.
Okay.
I remember it very well.
So
I was actually just looking up to see what day of the week he was arrested. I mean, I know the date. So it was a Thursday. So this case, the arrest occurred in this case at 3:45 p.m. on a Thursday afternoon in July. And as it turns out, this was a referral. It was a family member of somebody else that we had represented in the past. So there was some relationship, and that's how they knew to reach out to us. We were contacted by this individual's spouse, who told us that that her husband was in custody, and we were able to take a look through. Fortunately, some of the things that are nice about technology, when somebody's booked into the jail, there is a record entered in the jail database, and you can search it. Here in Miami-Dade County, you can just type in to Google Dade inmate search, and then if you know the person's first name and last name, that's all you need. You type that in, bam. Now, it won't appear until they're actually booked. So it didn't come in until a little bit later. It takes a couple hours. But once they're booked, you get to see a photograph of them. You get a jail number. You get a corresponding case number. You get to see what the charges are. And you also get to see the standard bond, or if there is no bond, or if there are any additional holds in this case. So in this case, this individual was arrested. As we said, it was a cocaine trafficking case. It was a 2-kilo case, which is a pretty large quantity of cocaine. It's 4.4 pounds of cocaine.
How many grams in a kilo, Mike?
Yeah, that 1,000.
Okay,
right?
so we're dealing with 2,000 grams for those of you out there that aren't really good with the metric system.
Well, fortunately, the narcotics industry has made the metric system popular in the United States. That's the only reason anyone knows it anyhow. So this individual is now in custody. There's a standard bond in this case. It's $500,000. This guy doesn't have that kind of money. He can't post that bond, and so he has to sit. We go to the bond hearing, and we have to decide, how do we deal with this? Because bond hearings occur within 24 hours of anybody's booking into a jail in the state of Florida. They have to be taken in front of a judge. And the purpose of that hearing, that initial appearance within 24 hours, is twofold. First, the judge is supposed to review the sworn statement of probable cause by the police and make a decision as to whether or not probable cause appears from the four corners of the document. This is not a trial. Defense attorney can be involved in this. You can make argument to the court, but at the end of the day, all they're tasked with doing is reviewing the four corners of the arrest document and deciding whether or not, based on a review of that document, the threshold for probable cause exists. If it does.
So Mike, how did you get him out of jail?
Well, we've got to fast forward, because what happened first off was we knew our client couldn't make a $500,000 bond. So we moved for a bond modification. We asked for a reduction because we knew $500,000 bond to this gentleman was tantamount to no bond. And of course, it's legitimate. The court could have stuck by their guns, but in this case, we were able to get them to agree to reduce the bond, I believe, to $100,000 with a special condition of GPS monitoring, plus what they call a Nebbia condition. You want to field Nebbia for a moment?
Sure. Well, let's talk about a couple of things. When you're talking about what is a judge looking at when they're determining whether or not a bond should be reduced, or determining about how a bond can be tailored to specifically do a couple of things. Number one, risk of flight. There is a 15-year minimum mandatory prison sentence that comes along with these charges, period. Right?
15-year min-man against a 30-year maximum sentence.
Right. This is a drug case. This is a drug minimum mandatory. That means, when I say minimum mandatory, that means day for day in prison. That means if you're sentenced to 15 years state prison, you do 15 years in state prison. There's no game time. There's no good behavior. There's no programs where you can do arts and crafts and get time off your sentence, things like that. It's hard. That is hard. That's 15 hard. So a judge has to look at risk of flight. Is this individual an individual that may consider, you know what, I don't want to fight my case, I'm going to flee? And I think many experienced judges look at a couple of things right off the bat when they look at risk of flight. Well, why has this individual hired attorneys, Morris and Haber? Well, if he's hired attorneys to come in here to structure a bond package, risk of flight is something I have to consider, but I'm going to be a little bit now less concerned that he's hired counsel, and I'm going to be addressing some of the things that could prevent flight, like ankle monitors. So
also on risk of flight, we have in this particular case, the individual is a South Florida resident. He's a U.S. citizen, but he's also a dual citizen with another country. So those are factors that the court needs to consider. He's got young children who were born and are American citizens, were born here, go to school here, grew up here, all their friends are here, their school is here. These are all factors that the court will consider as well, because somebody who does not have those types of what we call ties to the community is more likely to be able to pick up and leave than somebody who is rooted for these types of reasons.
Right. Well, let's also talk about the fact that he was a U.S. Marine and he has no criminal prior history.
Right. I didn't.
Criminal history.
So we have those things, and then you've got the second tier of it, which is danger to the community. And in this particular case,
well, before you get into that, Mike, let me address Nebby, which you asked me to address too.
Yep.
So you've got all these factors that the court has to take into consideration, and it's the defense attorney's job to present these facts to the court that's going to make a decision. Now, Mike, you handled that 99% of the pretrial here. And packaging this for not only the court, but you've also got to run this by a prosecutor. And there has to be a prosecutor who's experienced in drug cases and understands that, the bond, it's very hard to keep an individual locked up prior to a trial when it's a nonviolent. No matter what you say about this case, Mike, it's nonviolent, correct?
Well, except for one thing, and that is that there's a presumption, a statutory presumption, that any narcotics trafficking case is a crime of violence, even though it's not a violent crime. No guns were involved, no shooting was involved, but it is a factor that the court considers, and they are entitled to consider that.
Yes. And in this particular case, our client got the benefit of the doubt regarding violence. Now, again, he has specific ties to the community, children, wife works in a hospital. Had all these factors going for him that could allow a judge. And again, the no prior criminal history is very, very important. Let's face it. If you have prior criminal history, or someone that you're getting an attorney for, that's going to be looked at by a judge. Okay, even criminal contacts with the system without a conviction or something that courts look at, they always do. They get a printout. They get a, whatever you want to call it, a rap sheet, a criminal history printout. These are also factors. But let's get into money, because drugs and money go together like this. And there's a huge fine on that 15-year minimum mandatory too, Mike. Besides the 30 years, the 15-year min-man, what's the fine associated?
$500,000.
$500,000. So the money that you come up with to bond out, to give to a bondsman, you have to be prepared to show the prosecutor and the judge where that money comes from. Makes complete sense, correct? Makes complete sense that the money that you're using for your bond has to be clean. It can't come from illegal sources. It can't come from drug money, all right, or the proceeds of a drug transaction. So how do you do that? And Mike, I'm going to turn this back over to you, because you are pretty much, in this case, you handle that, but you're an expert in this. You work with a bondsman, correct?
So we start with a bondsman, but at the end of even before you get there.
So how do you show it's clean money, Mike?
Right, even before you get to the bondsman, you have to figure out what the family has. Where do they have money? Do they have assets? Do they own a home? Do they have jobs? Do they get paychecks? Do they have savings accounts or IRAs? Anything that's legitimately documented that can show a legitimate source of funds. And these people, unfortunately, like many people in today's America, pretty much live day to day, week to week, paycheck to paycheck. And in this case, our client wasn't working. He's traumatized from his service in the Middle East. And his wife works full time and basically supports the family, and he gets benefits from the government. So these are not people of means, which is why that $500,000 bond was outrageous. But even trying to come up with the $100,000 bond, which means you need a $10,000 premium, which means you need 10 grand that you can show is legitimate money, where does that come from? And in this case, we had to work very, very aggressively with the family. In fact, they wound up taking out bank loans and credit card advances, because there's no way to deny that a bank loan or a credit card advance is not legitimate money. It's not money from a drug transaction. It's not illegitimate money.
Money from a bank.
Right. If you're getting money from a bank, you're drawing money off of a credit card, that's legit money. So we were able to ultimately craft together enough cash to be able to, and legitimize it, to be able to satisfy that Nebbia condition. But the problem that we came up with subsequent to that was the GPS monitoring. So for you folks to understand, number one, bond is bond, and judges can structure pretrial release conditions pretty much however they wish.
Right. Hey, Mike, what's the difference between bond and bail? In case some people are watching right now and they're wondering, I hear you talking about a bond, but how is that different from bail?
Well, they're basically interchangeable terms. Right. There are legal distinctions, but for our purposes, they're interchangeable. Right. So when I want to focus on the pretrial release condition, because if you get arrested here in Miami-Dade County, a judge has the alternative in any case. In fact, many times the judges will give you a no cash bond and just put you out on GPS monitoring.
Which is house arrest, correct?
So, and we're going to talk about house arrest in a second, but right. When they do that, what they're basically doing is they're saying, we're going to give you a break in terms of not requiring you to come up with and expend funds, because on a $100,000 bond, you have to come up with $10,000. 10% is the statutory premium for the surety to post that bond. So a judge might say, you know what, I'm going to give you slack. I'm going to give you a break. I'm not going to make you cough up that 10 grand, but I'm going to put you on an ankle monitor. And then, of course, they can charge you or waive the cost of supervision if they wish, depending upon however they want to do it. Dade County has a monitored release program. It handles both pretrial release, which is house arrest, meaning that you're on some form of lockdown, whether it's 24/7 or whether they give you roaming during certain times of the day to go to school or to work, or even if they give you free roaming, allowing you to go wherever you want, they're just tracking you 24/7. But either way, the problem that our client had is he's not a Miami-Dade County resident. He lives in Palm Beach County. So Miami-Dade County monitored release program would not supervise him. So we had to actually locate a private GPS company, which we could hire, which we could present to the court and to the prosecutor to demonstrate to them that it's a legitimate monitoring company that could be sworn in and placed under oath by the court and directed that they're under a court order to advise the court if the defendant steps over the boundaries of the GPS monitoring. So, you know, it was a very, I got to tell you, we spent so much time litigating and dealing with the issues of pretrial release in this case, which took.
Right. We haven't even talked about the facts of the case yet because we're still trying to get this guy out of jail.
He sat for several weeks trying to get this done. That's how difficult it was. But ultimately, we were able to get it done. We were able to satisfy Nebbia. We were able to get a private company that the court and the prosecutor were satisfied with, and he was able to get released. That allows us now to get into the meat and potatoes of the case because we've gotten him out. But understand that if we were billing by the hour, if I were charging an hourly rate for that, they probably would have spent $25,000 just on release.
Yeah, because in this particular, well, I mean, you know, we don't have enough time in the day to talk about all the pitfalls of the judge that initially heard this, the division judge that didn't want to let him out, and a prosecutor that had second thoughts about it. And, you know, I don't remember how many prosecutors we ended up going through. We ended up with a very, you know, seasoned, very, very good prosecutor at the end. But we went through how many judges too, Mike? Did we
so we went through 4 judges, and we went through one set and then a second prosecutor. So right. the first judge, you know, I mean, I don't even want to say what I want to say about that judge. I'm just glad that judge got reassigned a couple of months into this case, and we got shifted to another division only because of that judge was reassigned. The second judge that we got was very competent in terms of his ability to handle this case, definitely experienced. He's a former defense attorney, handled plenty of trafficking cases, and really understood everything, which helps us in terms of the litigation. Because again, one of the factors that Mark and I need to think about, or any responsible defense attorney needs to think about before we're quoting fees, is, are we going to be fighting your judge, or are we going to have a judge that's going to help us to move this case along? Because the difference between a 3 or a 4-day trial and a 2-week trial is a judge who understands the law, the rules, and the facts. Our first judge hit none of those marks. 0. Our second judge,
he wasn't a judge who had the experience in this particular area, and that goes to, you know, judges get assigned to the criminal division that have not tried drug cases in their career. Now, is it their fault? No, it's not their fault, but they're put into these positions where they have to make rulings on things that they don't have any experience in. And I want to take this opportunity to let your viewers know, Mike, that, this case, how long again? 2.5 years?
Almost 2.5 years.
Okay. If you're watching this and you're somebody that has a case right now and you want a second opinion on it, you want another look at it, you want some eyes to look at it, give Mike a call. He's putting his information up right here. That's what we do. If you like the way that you need to have a couple of attorneys, a couple of chefs in the kitchen stirring the soup for you, here it is. This is the opportunity. We have the experience. If you're this particular case, 4 judges. I forgot that it went through 4. I had 3, but yeah, it was 4. Drug cases in particular are a specialty. This is not a grand theft auto case. This is not a burglary case. This is not a white collar crime case. You're stealing from the homeowners association. This is a narcotics case, and as you can see, we spent the first 20 minutes of the show just trying to get a client a bond that he or she could make in a case. So. This is an experience. This is a case that needs experience to look at it, even more so than a judge would have in a case like this, Mike. Would you agree?
Absolutely. And I want to throw in that one of the things that really helped this case and this client, and even though Ed's not here, I want to give him the same props because he is in the same boat as you in this regard. Both you and Ed were assistant state attorneys in the Miami-Dade County State Attorney's Office. That's how you both started your legal careers. Yeah. And you were both assigned as specialty prosecutors in the dedicated narcotics division. So this was your bread and butter for a while as a seasoned, experienced prosecutor. You were handling cases like this against the best of the best.
Every day. That was all I did with these cases. And you learn. It's not just that there is a template. We'll go over that in a minute. But there's absolutely no substitution for experience on both sides of the aisle. And Ed will tell you the same thing, and I'm sure he has on the show. This is your 81st show, by the way. Congratulations.
Thank you.
Fantastic. I'm sure in those 81 shows, Ed has mentioned that he was a former narcotics prosecutor.
Only about 87,000 times.
Okay, but you know what? He earned it. And he did his time in that minute.
As you did. And so your expertise in that area allows you to deal with some of the more complex litigation issues in these cases when we handle them. And I want to talk just about a couple of things factually in this case, because when we're assessing the case, we have to take a kind of global approach to everything. And this is something else that I talk about routinely in the show is, there are some lawyers who just focus on the prize, but we look at a bigger picture. We try to play what we would call 3-dimensional chess. We're worried about the case, but we're also worried about those things. Remember that first rule of litigation, that you got to expect the unexpected. And then we're also worried about what happens if you lose. And so we're always building mitigation at the same time. So this is a multifaceted approach that we're taking. But I'm going to throw out some terms in this case that I'm going to let Mark field, or ask Mark to field, that were really the significant highlights factually of the case. I want to talk about sting operations. I want to talk about confidential informants, and I want to talk about joint task forces and when and why the feds would hand off a case to the state. So let's start with the concept of a sting op and explain how it happened in this case.
A sting operation is when you target a particular individual. Now, this particular case involved informants, okay? CIs, confidential informants, snitches, rats, whatever you want to call them. They're employed by, in this particular case, the government, right? And
specifically, they were federal DEA confidential informants.
So many years ago, I don't even know when it started. You had, I think this was HIDTA, okay? HIDTA stands for High Intensity Drug Trafficking Area. Congress gave money to specific places in the United States, cities, Miami being one of them, and said, you know what, we're going to team up local drug agents from, in this case, Miami-Dade Police Department, right? South, Mike, where were they based out of? South. Okay, Miami-Dade police officers, detectives, with DEA agents from the Miami field office, and they put together these what are called task forces. And they combine resources, essentially. right? They're looking for the same thing as they do in federal and state court. They're looking for drug traffickers. And all of them will tell you, every DEA agent, every detective will tell you the same thing. We need informants to help us identify particular targets as drug traffickers or money men or brokers. There are three separate ways to handle a drug transaction. There's a buyer, there's a seller, and sometimes there's, just like a real estate transaction, a broker that puts a buyer and a seller together. Now, our client was targeted by federal informants, confidential informants. We didn't know who these individuals were until a couple of, how many years into the case did we find out?
More than a year and a half.
More than a year and a half. So our client was targeted, and this investigation on our client started in what year, Mike? Geez, 2018, I believe, right? Phone calls started being made to our client from an informant in 2018, and it continued. Now, when COVID took over society, and I want to say March of 2020, when did it really hit home?
March 2020.
March of 2020. Things slow. A lot of criminal investigations got slowed down. Those of you out there that remember COVID at that time, things were being shut down left and right. Well, that had an effect on criminal law, had an effect on the court system, it had an effect on the police departments, had an effect on everything. But this investigation still maintained itself because it was being handled by an informant who was making phone calls and recording them talking to our client over time.
Some of them, anyhow.
He was working them.
Right, but he was we don't know that he recorded all of those calls. We suspect
we're pretty sure
that were not recorded.
We're pretty sure that he didn't record all these calls, and that's a whole other episode. Is how much rope do you give to these informants? If you're a DEA agent or a Miami-Dade detective, do you let these guys just go out there and do their own investigation and make their own evidence? Because in this particular case, that's exactly what was going on. There wasn't a lot of supervision, and you had these, almost like free agents operating out there. Now, our client was a U.S. Marine, served in Iraq. He did some real dirty work out in the desert, ordnance work, mines sweeping, and he came back. What was that
Jeremy Renner movie?
That was the Hurt Locker.
Yeah, so that type of stuff.
He wasn't a bomb tech, but he was out there doing that type of work, locating to do what? To protect his other Marines or other U.S. soldiers or assets out there. For all intents and purposes, our client, he served frontline and, during and served in Iraq. He came back and he had some damage done. He had some physical injuries, his knee, his ankle, back,
and mental injuries,
trauma,
maybe more importantly.
If we have veterans, I'm sure, to watch your show, they know exactly what it is that I'm talking about. And Mike, as part of him being out on bond, there were times that he would have to go to the VA and have surgery and have to have that ankle monitor detached for a while. You think that's easy, just to take it off? No, the court has to be notified to give permission about it.
It was a train wreck.
It's intensive work. Okay, so we started looking at and listening to these phone calls as an informant. Sort of sounded like he was trying to take advantage financially of our client, saying, he had to make some extra money doing this. And this is 2018. You can make some money doing this. It's 2019. These phone calls started to add up, but nothing happens. Our client doesn't do anything during these years. 2020, the whole year. Phone calls. Hey, do you want to make some extra money? And our client's like, well, no. Nothing happens until 2021.
July 2021.
July 2021. I'm going to hand it back over to you in a minute to give you those facts. But when we're defending a drug case, there's only so many defenses that you have in a drug case. That's it. There's only so many defenses that you have to a sting. When your client is caught red-handed with either narcotics or money for a drug transaction, you only have entrapment as a defense. You don't have identification, really. Identification is was that you that showed up to the deal? It's either you or it's not you. If you're on video, it's either you or it's not you. And the only other legal defense would be something like insanity, but that's nice to talk about on your show, but it's not a reality. It's not a realistic defense in a case like this. So we had to go with a guy who has no prior drug trafficking charges, no prior drug convictions, no prior drug arrests. His defense had to be entrapment, and that was it. And because this case dealt with informants who are not government agents, okay, they're civilians, and they're working. When you talk about informants, why are they doing what they do? Are they paid to do this? Are they paid for a result? Are they working time off their own cases? Why are they setting up an individual, lying to that individual about doing a drug deal, which they know is going to be supervised by the US government, and it's going to be a trap? At the end of the day, a sting is a trap. It's to trap you with either drugs or money, and to take both of those from you, plus yourself, and put you in prison for 15 years in this particular case.
And or to get you to become a confidential informant yourself.
Or to what they call, that's called flipping you.
So that was the first thing that happened in this case. When they arrested our client, they attempted to flip him, and he told them, basically flip them off.
Right. And just for a second, for those listening, how does that go?
You mean in terms of what are the, well, basically in a 2 kilo cocaine case, it probably doesn't go this way, but in the average case, we see this all the time. You and I have had dozens and dozens of cases like this. In fact, on the same intersection in Weston, where the BSO hang out, just waiting to stop kids, young people driving their cars at 1 or 2 or 3 in the morning on a Friday or Saturday night. They find a little bit of weed, and then they tell the kids, you're going to prison for 5 years unless you wear a wire and, go buy more weed for us.
Yeah, the good old days. State Road 84 and Indian Trace, by the way.
Right. So, I mean, it's like you can set your watch by it.
Yeah. And just a quick note, a blinking red light, everybody, means what?
Stop.
A blinking red light, when you think nobody is watching you, it's the perfect time to just stop and say somebody's watching you. Otherwise, you're getting pulled over.
And then they're going to flip you or try. So in this case, just briefly going over the facts, because of course, Mark and I get the probable cause affidavit, the arrest report. We read through it, and basically it tells us that this is a federally it's a joint narcotics investigation with Miami-Dade Police and the DEA. They're using a federal confidential informant who negotiated a deal for 2 kilograms of coke in exchange for 64,000 US currency. The deal was brokered through phone calls and phone text messages. On the date in question, the informant contacted and spoke with the defendant, who said he was in possession and ready to consummate the deal. The DEA and Metro-Dade Police picked the time and place, told the CI to tell the defendant that's where they were going to meet. And of course, they were set up in this very public parking lot. They had probably 6 or 10 different police, undercover police vehicles, all of them with separate video equipment. The confidential informant was wired.
They look like shoppers at Home Depot in their cars, right?
They have this thing covered 6 ways from Sunday. Now, look, in fairness to them, they're doing 2 things. One, they're documenting to the best of their ability the transaction, because as Mark said, how are you going to say it wasn't me? I have an alibi when you're on videotape delivering 2 kilos of cocaine to an undercover or confidential. And secondly, of course, is officer safety and the safety of their confidential source. Things can go south in any case, but drug cases in particular, one thing could have been a drug ripoff. Who knows that our client, for all they know, our client was going to pull a gun and try and rip this guy for the 64,000 in cash and never deliver the dope. So everybody, believe me when I tell you, 6 ways from Sunday, they've got this thing covered in this parking lot. So they broker it, they set up the time, they set up the place, they set up their video and audio surveillance, and they send tactical members all over the place. And then at one point, they already know our client. They followed him around. They know his car. They know where he lives. They've got DEA agents up in Palm Beach following him down here.
Right.
They're in constant communication. These are not guys that are screwing around. They're covering everything.
Mike, what's the difference between a federal CI and a state CI?
One works for the DEA and one works for a municipal.
Right.
They're, as you said, they all fall into the same category in that either A, they're people who have been arrested who are trying to get favorable treatment in their case by working for the government and creating new cases, or B, they're people sometimes who have never been arrested but are paid because they're in the industry. The government knows that they're in the industry, or even if they were arrested previously and they're out of the industry now, they know they can make a living without getting a real job by simply working for the government and making cases.
Right. And how do they get paid? And how do they get paid?
Or there's the worst sort, which are what I call the Dudley Do-Rights. And those are the guys who have absolutely no financial or personal stake in it other than they could never be cops, so they want to be confidential informants.
They're collaborators.
Yeah, they're the worst. So in any event, this incident occurs. They've got our client pulling into the parking lot. They've got him on video. They've got him on the telephone with the CI saying, I'm here in the parking lot. Where are you? They're coordinating. Our guy walks up to the vehicle where the CI is. Again, this is all on video and audio. They have a conversation. You know, it's kind of like that scene from Scarface, right? You got the money, you got the stuff, you got the money. Well, I'm not going to give you the money till you give me the stuff.
It's close by.
So ultimately, our guy has the dope in his vehicle. And so he gets into the CI's car. The CI backs out and pulls up into a parking spot right next to our client's car. Our client gets out, grabs the dope, gives it to the CI. The takedown, once the CI determines that it's cocaine, he gives the prearranged takedown signal. And then, you know, the gates of hell open up and law enforcement floods the area and our client gets taken into custody. He's advised of his charges. He's read his rights. He invokes. Good job by our client.
When you say invoke, those people that are listening, what does that mean? That means
anybody
you have
who
the right to
watches
remain silent. Use it.
Everybody who watches this show is familiar with hashtag UpX2. He shut up and he lawyered up.
Okay.
He was simply arrested and taken to the jail and booked into the jail. And then there were two little curiosities, two little things that popped up that were ultimately a little bit uncomfortable for us. One was there was a baby seat in the back seat of the vehicle, although fortunately there was no child in the car because that would have been a much bigger deal in this case. And then there was also a loaded magazine, although there was no firearm found in the vehicle. But there was a magazine with ammunition in it. So that
was kind of random. Even like, you know, that was, when I looked at that, I'm like, oh, the agents are going to have a field day with this and the prosecutor. But surprisingly, that didn't move the needle at all for anybody, not even the judge. It's Florida, you know, maybe it's the environment we're in. There was no gun though. Simply, when you say magazine, there was a clip. And it was in the back and it was mixed in with things. So it looked like he totally forgot to take the clip out whenever he went shooting or whatever he was doing. And there was absolutely, so we get this right, there was no firearm associated with this case.
And it's very important because
he's not a convicted felon.
If there was a firearm involved in this case, then it would have been armed trafficking. And that would have
wouldn't be doing this show right now.
Right. That would have ratcheted this up from a first degree felony to a felony punishable by life in prison.
Right, all kinds of different min-mans on
that.
Yeah,
that would have been much worse. So, you know, I guess that's another pro tip. If you guys are going to get involved in any drug transactions, leave the guns at home. Do not be armed during the course of that transaction.
If you want to go to movies, let's go to Jack Nicholson in what's the Departed, when he's yelling at the Chinese nationals for bringing machine guns to a hard drive. They're selling zip drives or whatever, those flash drives. Or I forgot what it was, or motherboards. And he goes, we don't bring guns to drug transactions because we don't want to spend decades in federal prison.
Exactly. So now we know the facts of the case. I mean, obviously, we've already quoted a fee in the case, and we structure our fee based on the work that we believe that we're going to be called on to perform, the amount of time that we believe we're going to have to put in the case. And hey, we could get it grossly wrong as we did in this case, because this case turned into a complete shit show from soup to nuts.
Right. Also, Mike, let's stop right here and tell everybody that we had a client that told us from the beginning, kind of made it easy.
Yeah, he's going to trial. He's not accepting any deals.
I'm not stepping up in a courtroom and pleading guilty to this and taking 7 years state prison or whatever the offer was, or 10 or whatever they started to throw out. You know, and then they threatened us when we wanted the informant. We wanted to know the names of the informants, or at least have them come forward so that we could take statements or find out who they are.
Let me cut in there for a second. So
take that ball.
As we start dealing with this case and we file our appearances and we get the discovery and things start rolling, we already knew it was a CI case and we knew it was a joint task force and we knew it's in state court. So that's very important, because we also know, and this is really Mark's ballywhack more than mine, but we also know it's extremely difficult and very, very rare for federal agents to subject themselves to state court proceedings. They just don't do it. And you can't force them to do it because the state court has absolutely no authority. You can subpoena them until you're blue in the face and they wipe their ass with that subpoena and throw it in the garbage. And they can't be held in contempt. There's nothing that can be done to them. They're immune. So we knew we had this, which can work for you or against you, obviously, but we knew we had this going from the get-go. So we get to the point where we say, okay, fine, we have to know who these CIs are and what their motivation is. So Mark drafts and files, and we ultimately litigate a motion to disclose the confidential source. In other words, we want the court to, we ask the state says, no, we're not telling you. So now we go to a judge and we have an evidentiary hearing. And our first set of prosecutors, who really had no business handling this type of case, but their position to the judge was, we're not going to disclose the CI, even if you tell us to, because we don't plan on calling the CI because we don't need the CI to prove our case. Now, of course, our first judge, was not the judge who heard this motion. He fortunately handed it off to a much more versed judge, who basically his eyes were rolling like the pins on a slot machine during the course of this hearing, when he ultimately said to the state, look, I'm not going to tell you how to prosecute your case, but I am going to tell you this: you proceed at your own risk. Right. Well, fast forward through that, once we knew that the state, that was their position, Mark and I did the only nuclear bomb that criminal defense lawyers have in a criminal case.
Well, let's back up for a second, because I had to do what's called the C4 motion to announce entrapment as the defense, which then pressures the court to have to make and also the state to have to make a decision. Okay, we have to respond to this motion to dismiss by what's called a traverse, and this gets into the weeds of some very hardcore motion practice. But essentially, we put the state in a position where they were going to have to tell us who the CIs were at some point, because if you're looking at their case, as Mike, you just said, the judge is rolling his eyes. The prosecutors, I don't know what they got wrong there. First of all, their CIs did this whole deal. Their informants did the whole deal. There was not one undercover detective or undercover DEA agent in this case at all. Zero. There was not one time there was not on a meeting, like an undercover meeting to introduce anybody. None of it. It was all done on phone calls and the informants meeting with our client at weird dates, during COVID at weird times.
So because the state doubled down on the fact that they were not going to disclose this guy, Mark and I dropped a written demand for speedy trial and accelerated the case.
Right.
In the meantime, our judge got reassigned, and we wind up in front of another judge, our second judge, who was very experienced. He had our speedy demand. He set our case for trial, and we now got a new prosecutor. And the new prosecutor took one look at this case and realized that she had some serious problems based on what her predecessors had done. And so the first thing she did was disclose the CI. She gave us the name. She offered him up to us and gave us his CI file, told us, gave us everything that she had on this particular guy. And we decided, that's great. We're ready. We're still going forward. And so we did. And we went to trial.
Right. That's what we did. The demand for speedy trial, I don't know if I'm sure you've talked about it on your show, but give the listeners a quick version of why a demand for speedy trial, why we wanted to do that, and what benefit does it have for a client who's out of custody?
So
basically, we do that for somebody that's in custody to speed it up.
Basically, anybody who's arrested and accused of a crime has a natural speedy trial window.
Right.
A period of time that the state has to take you to trial, in 90 days in a misdemeanor, 175 in a felony. But if the defendant causes a delay, if you take a continuance, if you do anything to slow down that process, that time frame is blown, and now the case can continue until it gets resolved. However, the defense can always file what's called a written demand for speedy trial, or if you're Gail Levine, you can, the state can do it too, right? But the defense can file a written demand, and basically what that says is, Judge, we are invoking our right to a speedy trial, and you must take us to trial within 50 days of this demand. So it accelerates the litigation in the case. It still gives a buffer of 50 days, And during that time, everybody has to get their gear together. And the defendant is basically saying, we are ready to go to trial today. Let's go. So we wind up going through our stages, and we pick a jury, we select a jury, we impanel a jury, we begin the testimony.
On our defense, remember, we had to pick a jury now that's going to have an open mind about entrapment. It was a very difficult
I wish we could spend more time, but we're
how much time do we have left? I don't
15 minutes. We've already sucked up 3/4 of the show. So I'm just kind of speeding it up a little to get to the meat and potatoes. But at the end of the day, the confidential informant made, during his direct testimony very early on, made some horribly inappropriate statements that resulted in a mistrial, meaning the judge had to excuse the jury and just call foul. It was not intentional. The state didn't do it on purpose. The witness, is a moron. And these things happen. In the meantime, our client now, who had a jury, who was under a speedy demand, who felt good about his case moving forward, has to start over. It's a complete hard reset. The speedy trial demand has been satisfied once the jury was picked, so that's no longer an issue. Then some things occurred that we don't really need to get into the meat and potatoes of, but suffice it to say that the judge was uncomfortable proceeding as the judge in this case, so he recused himself, and we got bounced to our third judge. Our third judge was very similar to our first judge in that he had absolutely zero experience in the criminal realm, yet here he is presiding over a very serious 15-year minimum mandatory first-degree felony, in an entrapment case with a lot of nuance. And without spending too much time on him, let's just say that we didn't want him. We asked him to recuse, as opposed to our second judge.
We had good reason. And
right, but I don't want to get into the weeds of the why of it. Just to say,
well, do you want to talk about depositions of informants and why we didn't?
No. Okay. We're not going to have time to do that right now. But let's just suffice it to say that our third judge, we moved to recuse him, unlike the second judge who recused himself. That's called sua sponte recusal. The third judge, we asked him to recuse. He said, no, I'm not recusing. And then, believe it or not, the prosecutor jumped on board and said, Judge, we don't want you either. We're moving to recuse you. And at that point, the judge...
And you just can't say that. We had good reason. So just not
everybody was on the same page with regard to judge number 4.
In fact, it was my first motion to recuse as an attorney in my 32 years. I've never done one, ever. Not as a prosecutor, as a public defender, not as a private attorney. I've never done one before, but circumstances were so ridiculous with this judge that protect our client. Forget about me, forget about you. We have a duty this whole time to protect the client when we see a situation that could put the client's liberty at peril. And that was exactly what happened in this case. And you know what, Mike? Look, we both have a platform to use to talk to the public. You have this show, I have my social media, and it's a different day out there. It's a different, we have the ability to talk to listeners who are still with us, hopefully listening to this case, that if the opportunity to protect our client puts us in a, maybe it'll put me in an uncomfortable position with a few judges, too bad for me.
Exactly.
Too bad for me.
We got to do our job. But to show how right we were, again, when that judge doubled down and basically told us to go pound sand, he was going to cram it down our throat anyhow. Yeah. The prosecutor jumped up and said, I don't want you.
Well, she was affected by it. Yeah, she was affected by it.
The state doesn't want you. We don't trust you. And so, again, this is it's almost unprecedented, but that's how god awful this
it was insane. It was really, sanity had left the building for a couple hours.
Now we get assigned to our fourth judge. And of course, the process is still ticking along. This case is now, pretty much 2 years old. Our client is out. Now, he's paying every month privately for this ankle monitor that he's still wearing. He does have free roaming, which we were able to get him. So it's not that horrible, but it is costing him money. And then there's the emotional tax of having a case like this hanging over your head. It extols a very big price, a great price on anybody who's in those circumstances. So But still, we know we now have a fourth judge, and the fourth judge is also similar to the second judge. He's an experienced former criminal defense lawyer. He understands the dynamics. He's perfectly competent to handle the case from a judicial perspective. And so moving forward, all things equal, we're okay there. We get called in for our first sounding. Just in case we've never touched this or you don't know, in most felony cases, they get set for trial on a trial date, but sometime prior to that trial date, usually about 10 days in advance, the judge has a status conference or a sounding or a pretrial conference, whatever they want to call it, a calendar call. The term varies from location to location and courtroom to courtroom. But the bottom line is it's a status hearing for the court to know whether or not the case is actually going to remain on the trial docket in 7 or 10 or however many days in advance. That way they can coordinate, because they have to figure out which case. This may be our only case in that judge's division, but that judge has hundreds of other cases in his or her division. So we get to the first status conference and the state says that they're not ready. And of course, the judge wants to know why you're not ready, particularly on a better than 2-year-old case that's already been to trial once. And the state says that they have a witness issue, and the judge inquires properly as to which witness. Lo and behold, confidential informant is unavailable. We don't even have to do the job because, again, we're dealing with an experienced judge here who presses the state on his own, which he has absolutely every right to do. Why is this witness unavailable? Mark?
The witness was unavailable because apparently the witness is in a federal correctional institution called Coleman Medium, which is in the center of the state of Florida. It's a federal correctional institution as a sentenced inmate. It's not FCC. It's not awaiting anything. It's not awaiting a case, a trial. He's actually, you have to be a sentenced inmate to go there.
So what
we find out, surprise, one of the informants, one of the two, and the one that handled the cocaine, all right, which sort of fits into our defense.
The more important of the two.
The more important of the two is serving time for something, and we don't know what for. We haven't been, this is information that the government hasn't provided to us yet, but they certainly were supposed to. So now they have a major problem. They've got to bring in somebody to testify against our client. And, this isn't like TV, where they can go up and get the witness and then drive them to a hotel. And, Michael Corleone said this and Michael Corleone said that. No, it doesn't work like that. You've got to get an order. The judge tried to help the prosecutor out by signing an order to.
Well, before we even get there, hang on one second.
Yeah.
So the bottom line with this guy is he was available when we went to trial at first because
we saw him physically.
He had already pled guilty in federal court to whatever crimes he was convicted of, presumably drug crimes, but he had not yet been sentenced or designated to his facility. And those two things occurred in between the first trial and this, which was in front of judge number 2, and the first sounding in front of judge number 4. So by that time, this guy's already gone. And
right. They kept it very quiet. We didn't know about this. And that's another issue. When are we supposed to know about that? We're supposed to know when a witness goes into federal custody.
Well, here's what we did. The minute that we found out this guy was unavailable, we dropped another written demand for speedy trial. And why did we do that? Because that, again, locks the government and the court into a 50-day window to take us to trial. And they got to have their witness to take us to trial. They can't, unless they're going to operate in bad faith, which this particular prosecutor would never do.
There'd be no link to if we're going to use entrapment, they have to have an informant.
Right, but we know there are unethical and uninformed and unprofessional prosecutors out there that play games and do stupid stuff.
Or ones that just don't have experience, Mike.
Right. This is not one of those prosecutors.
No.
This prosecutor was very on top of board. She didn't come to us and tell us in advance, but she was candid with the court when she had to be, and we pounced the minute that we heard it. Again, why? Because we're skilled and we're experienced. We know that it's going to be a nightmare for her, if it's even possible, to get that guy out of federal prison and into a state courtroom to testify. So we file that speedy demand and put everybody back on the clock. Run with it.
When you do that, then the prosecutor had a problem. How do I get get an individual, a sentenced inmate from a federal correctional institute into state court in Miami to testify? And it sounds like it would be something that's easy to do. Well, let's just go pick them up and we'll bring them to court. It doesn't work that way. You've got a federal institution run by Bureau of Prisons. Bureau of Prisons has their own rules. And when you are an inmate with Bureau of Prisons, they're responsible for you. Unless there's some type of federal, motion coming from a U.S. attorney to the U.S. Marshal's office to transport an individual, like where was he going to stay? It's not like the movies or TV when you put somebody up in a hotel room and they come to court. It doesn't work that way. And the state simply failed to be able to bring this informant to trial to testify. Now, even if they did, this informant would come into the courtroom. They don't get to change into a suit. They're inmates. They're sentenced inmates. All right. So that informant would come in and testify in the orange prison garb that you see, or the federal prison garb, which is, I believe, khaki, if you want to get factually correct here, Mike. So, as a prosecutor, you have to say to yourself, I've got an informant that's in federal custody. I'm going to bring this individual in front of a jury to testify about what they did by themselves in a case against a defendant, when I have defense attorneys that are going to get up there all day and cross-examine this guy and say, why are you here? Like, what are you getting out of this? Of course, what does that individual, that informant, want to get out of that? They want to get less time in prison. They'll say anything to get less time off their sentence.
It's fair to say that a prosecutor's, especially a young prosecutor, but a prosecutor's dream in court is to be able to cross-examine a defendant, because most defendants invoke the Fifth and don't testify. So when they get a shot at cross-examining a defendant, that really gets a prosecutor going, or at least it should, right?
It should, but there's not a lot of experience in cross-examination.
Exactly, which is why, again, it's juicy. That's like the ice cream for the prosecutor. For the defense attorneys, it's a snitch. There's no better cross-examination than that of a confidential informant.
Right, because we're entitled to really take, there's a lot of rope that's given to defense attorneys under due process in the Sixth Amendment, U.S. versus Alaska, to be able to go after an informant on motivation and manipulation, because you're lying. You're a professional liar. Informants are professional liars, and they have to admit that to juries. And are juries comfortable with the testimony of an individual who's going to have to admit, yeah, I'm a professional liar. I lied to this guy to get him to do a drug deal. I had to lie to him. That's my job. And they're doing it in federal prison garb. And as a juror, you got to say to yourself, in jury selection, a prosecutor is going to have to explain to a jury, I'm going to bring forth somebody who's in prison and another informant who probably had one foot in prison already, or is working to get another one out, or, there's all this motivation that we have to, as defense attorneys, bring out in cross-examination. That is our job. So, you had a prosecutor that looked at us and said, how good is my case? If I got a guy in prison who my case depends on, how good is it? And, I'd love to have her as a guest on the show to go through her process, because she's, prosecutors don't have to tell us why they're doing what they do, and they never do usually. When I was a prosecutor, I never gave an explanation unless it was somebody that I knew, or I thought the judge, needed an explanation. It's just not there. We simply don't, at this point, really, at the end of the day, don't know the exact reason 100%, but we know a bunch of reasons why that all added up to a dismissal in this case.
Well, at the end of the
thought, by the way,
at the end of the day, on the 50th day, the last day of the speedy trial window, the prosecutor announced a null pros. So we'll never get to know the motivation of this confidential informant. And I don't think our client is sitting up at night worrying about it, because the ankle monitor is off. He is now 100% free. This albatross is off of his back after 2.5 years, nearly, from July of 21 to December of 23. 4 judges later, he now has his freedom back, and he can now do whatever he wants on his own terms. And I will postulate that a lot of this has to do with the lawyers that he hired, knowing how to take advantage of loopholes and technicalities.
Mike, this is experience. We've done this before, from like we started this show, from the phone call to now to the dismissal. And that's why I want to remind people, if you've got a case that you want us to take a look at, reach out to Michael, reach out to him, because this is what we do. This is what we do with all our cases. It doesn't have to be a drug case, but we do, obviously listening, if you're still with us, thank you. But you've heard how we work a case. For 2.5 years, we worked every aspect of this case, every aspect of it. So give us an opportunity to take a look at your case.
Getting a 15-year minimum mandatory 2-kilo cocaine trafficking case dismissed is a coup. I'm proud of this one. We've had, you and I have handled a lot of really contentious cases, and we've won some really difficult ones. I remember one of our first homicide cases where our client unloaded a full magazine, 11 rounds into a guy, only one round in his side or in his side, everything else in his back.
Well,
sides.
He was still moving, Mike. He was still moving.
Well, and that was the defense. But even that doesn't feel as good as this to me. So look, it's a job very well done, but it was a job that was very well earned. This did not come easy. It did not come for free, and it did not come cheap. Although we worked much cheaper than we would have had we known in advance the way that this thing was going to go, and we did.
Of course.
So unfortunately, this is one of those cases where when you add up the hours and divide by the fee, we did a lot worse than we should have done. But it's also a case where our client got an incredible result. And to us, that there is a great deal of value to that. We are grateful and we are proud. And we are willing to, like Mark said, we're certainly willing to take a look at your case if you'd like us to, give you an opinion letter. And a second set of eyes and ears to take a look at it. It's not to criticize. You can put 5 lawyers in a room.
No.
One question, you might get 5 different answers. Doesn't necessarily mean people are right or wrong. We're all sentient. We all look at the world from different prisms. We have different perspectives and different experience. But at the end of the day, if you wanna run off of what happened with this case, at least you know where it resulted and how it got there.
Right. I mean, nobody has a monopoly on first opinions. So
as I say in my promo materials, this is an example of taking advantage of fortuitous, unexpected circumstances, or as I like to say, being proficient enough to be able to exploit loopholes and technicalities.
Look, Mike, it's hard. It was hard work from getting the bond to the motion practice to showing up for court every day last week. Seeing if a witness showed up, it is hard work. Your knuckles should be skinned right now. There's a lot of punches we're throwing in this case. The prosecutor worked extremely hard in this case too. I mean, my hat goes off to her because we made her work very hard.
Absolutely.
Okay. So
Absolutely.
Yeah, job well done. I'm happy to be able to come onto the show and talk about it today. Thank you for having me. I think we're running over your time slot.
All right.
Thank you for having me, and please have me back again when we win another one.
Absolutely. Well, we won't have to wait that long.
All right.
Folks, I want to thank you for paying attention. I know we're coming up on the holidays. I'm hoping that we'll be able to squeeze one more show in next week. But we certainly will not be doing one on Christmas Day, nor will we on New Year's week. So those 2 weeks we will take off. With any luck, we'll have episode number 82 next week on the 18th. Either way, thank you for allowing us to be at your service. I hope that you got plenty of pro tips and insight out of this show. We wish you all in advance a happy, healthy, safe, and prosperous holiday season and New Year's. Thank you again. And as soon as we get done with the show, our producers at Miami Communities Newspapers, who we also must thank, will upload this to various social media. We'll get a YouTube link, and we'll be posting that as quickly as possible. With that, thank you again, Mark. Thank you, Miami Communities Newspapers, and thank you, our audience. We'll see you all next week or in 2024, one of the two. Take care, y'all. Thank you.